and the state goes first and last. And so you may proceed.
Ladies and gentlemen, you heard testimony. You heard from Diana, Henry, Julian, Amy, Sherry, Peter, and Officer Dorn. You heard that the neighborhood was quiet. You heard that the noise was loud. You heard that it was unusual. You heard it was scary and intimidating. Not disputed today is the defendant, Robert Jones, who's there. The date, December 8th, 2020. The location, Sandstone, Fort in Boise, Ada County, state of Idaho. That there was buckets, horns, and screaming that occurred, and that the noise was meant to reach a person inside the home. And that they only stopped because they saw a dog. Ladies and gentlemen, the state is going to ask you to return a verdict of guilty for disturbing the peace. Thank you.
You may give your closing.
Thank you. All right, you guys heard all the evidence now, all the evidence that you're allowed to hear. And I would like you to consider reasonable doubt. Do you believe that I went there with the intent of damaging or injuring somebody? In the jury instruction, it also says annoy. I want you to consider the videos that, yeah, while they are noisy and while it does get your attention, they lasted about 10 minutes. And we didn't stop only because of the dog, because the lady that came down with the dog went inside with the dog, and we still ended it because we were going to end it. Yes, we did end it a couple minutes early for that neighbor. I did not bring any of the materials to be loud. I came with a yellow vest because I wanted to be seen like I wasn't allowed to be seen at the government office. I did not even know which commissioner that I was going to at the time. I did not know that it was only her kids there. If I would have known that, I never would have shown up. I've got 6 kids myself. And I would never intentionally intimidate a kid. And yes, the neighborhood was going to hear it, and I knew that once we started making noise, the neighbor was going to hear it, but it was short. And we had already planned on moving on. The dog, yes, did take us off for about 5 minutes or so. I think we planned it for about 15 minutes. It was to be heard because we weren't being heard through official channels. That's why the high-vis vest. We left the neighborhood. As you can see, yes, we did honk our horns as we were leaving. We never went to any of the other neighbors. Our event was focused on the one house of the then county commissioner, where she had done public meetings from before.
And Your Honor, at this point, this is a claiming facts, not an evidence.
Okay. Did you wish to respond to the objection
I would like to
of
know
adding
what-
facts that were not testified to?
What facts weren't testified to that I said? The only one I can think of is that Luciano did stuff from her house. She said so on the stand.
Okay.
Is that?
And so I'll go ahead and overrule the objection. I'll go ahead and allow you to continue. And
Okay, I'm almost done anyways.
okay.
I would just like to remind you, I can't remember I'm really bad with names, and I can't remember which one of our founders said it, but it is better for 100 innocent men to go free than one guilty man to be found guilty. I stood for many that night, and I asked just one of you to stand for...
And Your Honor, I think that this is impermissible at this point. It's asking the jurors to get in the feet of the defendant, and that is impermissibly inciting the passions of the jury.
And I'll sustain that objection. And
I'll read it directly from the thing. I just want to point out this is in the jury instructions. That's allowed, right? Okay. However, none of you should surrender your honest opinion as to the weight and effect of evidence as to the innocence or guilt of the defendant, because the majority of jury, the jury feels otherwise, or for the purpose of returning a unanimous verdict. I get it. It's late. I don't know about you guys, but I'm tired. I got a headache. My stomach's messed up. Sorry, but okay. I know that it's been a long day, and I would ask the that your highest interest be in justice. I understand you want to go home, but please consider this as, like the court said, as a sacred duty, and that you would fully weigh the facts that, well, at least the ones that were presented to you today, and I would appreciate it being acquitted. If not, it's in God's hands. So thank you. I appreciate your time.
Thank you. And now, any state's rebuttal?
Please, Your Honor, and Madam Clerk, if I could have the Alma. I didn't mean to do it. I didn't want to break the law. I was trying to make myself known. Ladies and gentlemen, the judge gave you this instruction. Malicious and willful. This is really where Mr. Jones's argument beholds. I didn't mean to do it. There's nothing in here that says the state has to prove he intended to commit the crime. What the state has to prove is that it was willful and that it was malicious. There's an instruction here by Her Honor. Willful. An act is willful or done willfully when done on purpose. His testimony here today is that he went there to be noticed. When he saw those items, whether he brought them or not, that's a collateral issue. State does not have to prove that beyond a reasonable doubt. When he saw those items, he persisted to make noise. He told you on the stand he thought Diana Laciano was in that house and he wanted to be noticed. He told you just now in closing he wanted to be noticed. Those actions were willful, ladies and gentlemen. It is not an act. The state does not have to prove he intended to commit the crime. Mr. Jones may be a good person. That is not what the state has to prove or dispute in any manner. Additionally, the court will instruct you, and has instructed you, 1. Sorry, I grabbed the wrong instruction, but I'm going to do this one anyway. Do not concern yourself with penalty or punishment. That is not your position. That is up to Judge Clark. Your position here is the trier of fact. You determine what evidence to believe, what evidence not to believe. You are not to consider whether any punishment befall Mr. Jones. Once again, that is on Judge Clark. Finally, instruction 5, neither sympathy nor prejudice should influence your deliberations. Mr. Jones might be a nice guy. You're not to consider that. That's before the court. What you, as trier of facts, are to consider whether this action, because Mr. Jones's defense really is this: I didn't do it maliciously and I didn't do it willfully. I think we described, and he admitted somewhat unbegrudgingly, this wasn't a spasm. Instead, he went there to do something to get noticed. That is not disputed, ladies and gentlemen. Finally, you'll have this instruction of malice or malicious. Malice or maliciously mean, so it should probably say means, but mean to desire to annoy or injure or the intent to do a wrongful act. All put before the court. Those actions by that man, he desired to annoy not only Ms. Laciano, but that entire neighborhood. There's nothing within the instructions that requires that we state that it had to be a short duration, that it had to be a long duration. It is with the willful and malicious intent. And that is exactly what he was doing when he showed up to that neighborhood and decided to make the noise and decided to make himself noticed. And once again, I will implore you, look at the evidence. Scrutinize the state's case. It is our burden, but scrutinize it fairly. Those are the instructions before the court. And it is not the state's burden to prove whether this man is a nice human or not. Instead, it is whether these actions were committed willfully and with malice. And there is no other reason. Once again, even the instruction that Mr. Jones read to you, as a trier of fact, you can use your common sense. You can use your past experiences. There is no reason they showed up to not annoy someone. There is absolutely no absolute doubt.
Objection, Your Honor? There was. It wasn't allowed in court.
And
Does Your Honor wish me to respond?
if you would like.
If it's required, I don't believe that's a proper objection.
Okay. And so I will go ahead and overrule the objection as not having a legal basis.
Ladies and gentlemen, like I said, scrutinize the facts, don't leave your common sense. There is absolutely no reason that that man showed up to that house to bang on every single thing, to honk the horn, to blow air horns, other than to annoy every single person in that neighborhood. Because
Your
for
Honor.
whatever reason,
Objection?
he wanted to do it.
What is the legal basis?
He's stating facts, not an evidence. Evidence to the contrary, blowing the horn. I believe the cop even testified that he never seen me with the bullhorn. He never seen, I know I never screamed because that's not me.
So hang on a
Okay.
second. Why don't y'all come on up?
The final thing I'm going to say, ladies and gentlemen, is there was evidence presented before you today, potentially that the defendant or blowing the air horn and beating the drum. Look at all the evidence before you. Like I said, go in and scrutinize the state's case to do it fairly. I think at the end of the day, based on all of the evidence, you will find that the defendant is guilty of this crime.
Okay. Now, I'm going to have my clerk swear in our bailiff.
You swear to keep the jury together in a convenient place until they have agreed upon a verdict or are discharged by the court, that you will suffer no person to speak to or communicate with them on any subject connected with the trial, nor do so yourself unless by order of the court, and that you will return them to open court to render their verdict.
I will.
Good. We'll go ahead and provide you with our final jury instructions and verdict form and our evidence. Very good. We will now put the case in the hands of the jurors, and so if you will go forth and deliberate. Thank you.
All right, please.